Chapter 1 Preliminary Section Preliminary Section 1 to 3 Negotiable Instrument Act 1881 came into force on 1st March 1882. Under Negotiable Instrument Act, Bill of Exchange is defined under Section 5, under which act public holiday are declared. Negotiable Instrument Act 1882. What is the punishment for offence under Section 13 of Negotiable Instrument Act? 2-year imprisonment or fine, which may extend to twice the amount of check or both. Chapter 2 of Notes, Bills and Checks. Section 4 to 25. A. Sign an instrument in writing as under on demand. I promise to pay B the sum of rupees 10,000. What is it? What is this called? Simple note. Which written instrument signed by maker is a promissory note? Mr. B, I will pay you 1,000 rupees on demand, which is not a negotiable instrument. Bond. Negotiable Instrument Act 1881. If an amount written in any instrument is stated differently in figure and words, the amount stated in word shall be paid. Negotiable Instrument Act. I promise to pay B and all other sum which shall be due to him. This is none of these. Which one of the following is not a bill of exchange? Share, demand draft, post-dated check. None of post-dated check are bill of exchange. The term protest is used under NIA in section 100, include noting also. The statement is true. Check is a bill of exchange. The term check in electronic form is defined in NIA under section explanation 1A of section 6. The term negotiable instrument defined in negotiable in NIA under section 13. The term negotiation of Negotiable Instrument Act refer to transfer of bill of exchange, promissory note or check to any person so as to constitute the person the holder thereof. This section of NIA define negotiable instrument. 13. If minor draws, endorse, deliver or negotiate an instrument, such instrument binds all party to the instrument except the minor. The NIA became operative from the date 9th December 1881. Drawee in case of need has been defined under NIA under in section 7. Negotiable Instrument Act provide for payment of interim compensation by drawer of the check to complainant. Such interim compensation should not exceed dash amount of the check. 20%. Which one of the following statement is false? The defense of non est factum was evolved by judiciary to save the position of a person who signed the document but could not read it due to the blindness or illiteracy. This one is right. In course of time, the defense of non est factum came to apply other area also beside the blindness and illiteracy. This one is right. Doctrine of non est factum applies in the case of misrepresentation, inducing the mistake, belief in regard of class and character of supposed document. This one is right. This one is wrong. A minor borrows some money on promissory note. After attaining majority, he executes another promissory note in respect of original loan plus the accrual interest. The creditor filed a suit for recovery of the money on the basis of second promissory note. The suit is liable. To be dismissed as the money was not advanced to the minor for necessary. Which one of the following is not an essential requirement to fulfill an instrument intended to be a promissory note? Mere acknowledgement of indebtedness is sufficient. Who is holder in due course? A person who became possessor of negotiable instrument payable to bearer for consideration. Negotiable instrument is defined under Section 13 of Negotiable Instrument Act. Which one of the following is not a negotiable instrument? Fixed deposit receipt. Which one of the following is not an example of negotiable instrument? Share certificate. According to section 13 of negotiable instrument, which is not a negotiable instrument? Installment of debt. In which one of the following section NIA holder in due course defined? Section 9. If a check amount ordered to be paid in writing differently in figure and word, the amount written in words shall be undertaken and ordered to be paid. Which section of NIA public holiday is explained? Section 25. A sign instrument in the following term. Which instrument are promissory note under section 4 of NIA 1881? I promise to pay B in order of 500 to be paid on demand. Under section 11 of NIA, promissory note, bill of exchange and check or made in India are made payable or drawn upon the person resident in India is inland instrument. If the endorser sign his name and add a direction to pay the amount mentioned in the instrument to be specified person, the endorsement is said to be endorsement in full. A take a loan from B with promise to pay it back within 6 months. It is also stipulated that on failure to pay within 6 months, A will be liable to pay the double the amount borrowed. It is the nature of liquidated damage, so stipulated amount can be claimed. Given below are two statements, one labeled as assertion and the other labeled as reason. Read the statement and choose the correct answer using the given code below. Assertion. Negotiable instrument means promissory note, bill of exchange and check payable either to the order or the bearer. This one is right because it is said so under section 13 of NIA 18(1). A draw a check in favor of B, a minor. B endorse in favor of C and C endorse in favor of D. The check is dishonored. Which one of the following is not correct liability of the parties? C and D can claim from B. In which one of the following case did Honorable Supreme Court decided the issue of territorial jurisdiction of the court to entertain a complaint under NIA in reference to amending Ordinance 2015? Bridgestone Indian Private Limited versus Inderpal Singh. As per the provision of section 26 of NIA, a minor may draw instruments so to bind all the party except himself. Where a promissory note is not payable by installment and two or more installment have become due and the holder of note sue only for one of the installment, omit to sue for the other installment, he cannot afterwards sue for this installment. In case of promissory note which is not negotiable, no notice of dishonor is necessary. What is negotiable? Which one of the following is true about inchoate instrument? It is incomplete and blank negotiable instrument. At sight under section 21 of NIA means on demand. The undertaking contained in promissory note to pay a certain sum of money is unconditional. Who are the partner in bill of exchange? Drawer, drawee and pay, both. What is the term used to describe instrument which is not discharged even by presentation of instrument to the acceptor for payment? Bill of exchange. Section 16 of NIA define endorsement in full and endorsement in blank. Crossing of check affect the mode of payment of check. Which provision of the Act deals with payment in due course? 10. following is not an essential for applicability of Section 8 of the Act. The article must be in possession and control of defendant. What is necessary? Defendant must be the owner of the property. Article must be the movable. Plaintiff must be entitled to immediate possession of the article. Which one of the following negotiable instrument required acceptance by drawee before the payment can be demanded? Bill of exchange. What is a term used to describe endorsement in which endorser exclude his own liability on negotiable instrument in case of dishonor of instrument? Sans recourse instrument. Which one of the following is not correct regarding the presentment of acceptance? D is incorrect. Which is correct? Only holder of bill and other agent can be present the bill. Drawer himself can present the bill. If bill has been negotiated before acceptance, endorsee can be present in the bill. Chapter 3. Parties to notes, bills and the check. Section 26 to 45A. Negotiable instrument. Negotiation by endorsement has been explained under NIA in which section? Section 48. Under Section 97 of NIA, when the party to whom notice of dishonor is dispatched is dead, but the party dispatching the notice is ignorant of his death, then notice is sufficient. The term legal representative in Section 29 of NIA include executor or administrator. Under Section 23 of NIA, a promissory note bill of exchange dated 31st August 2018, it made payable 3 months after date. The instrument is at maturity of 3rd December 2018, August, September, October, November, December. Which provision of the Act deal with effect of declaration? Section 35. The Negotiable Instrument Act make specific mention of 3 instruments, namely check, bill of exchange and promissory note. What presentment for a better is to be made under Section 65 of the Act? Presentment for payment must made during the usual hour of business and if bank within the banking hour. Assertion. Where the bill is unintentionally cancelled by the holder on his agent and the cancellation is not apparent thereon, the bill is discharged. Above principle laid down in Section 82 of NIA. Both A and R are true and R is a correct explanation of A. Negotiable Instrument Act. Where a minor may draw, endorse, deliver and negotiate any instrument, yes, he may do so, as to bind all the party except himself. Chapter 9 of Noting and Protest, Section 99 to 104. Which provision of the Act laid down foreign bill must be protested for dishonor if required by the law, so the place where they can be drawn. Section 104. In which one of the following case did Supreme Court hold that complaint for dishonor of check can be filed at a place where check was lost, not where check was issued? Bringston India Private Limited versus Inderpal Singh. Match. Decision given by the Permanent Court of Arbitration. Pious Fund case. The principal doctrine of form of promulgated was initiated in the case of right of minorities in Upper Silsa Minority School. Leading case on reprisal is Nilula incident. Case decided International Court of Justice under contents jurisdiction. Asylum Colombia versus Peru. Chapter 10 of reasonable time, section 105 to 107. In determining the reasonable time for proposal of negotiable instrument, public holiday are excluded. Under section 138 of the Act, territorial jurisdiction does not arise on the following places: from where the notice to pay the amount is issued. Chapter 8 Specific Rule of Evidence, section 118 to 122. When a negotiable instrument is dishonored, the liability of parties pay compensation to holder. Which of the following are presumption as to negotiable instrument under section 118 of the Negotiable Instrument Act? B and D. Presumption as to consideration, presumption as to date. As per section 118 of Negotiable Instrument Act, presumption in regard to date of the negotiable instrument is that every negotiable instrument bearing a date was made or drawn on such date. Which of the following presumption is prescribed under section 118 of negotiable instrument? All of these: of consideration, date and time of acceptance. Negotiable Instrument Act 1881 provide for making which of the following presumption as a special rule of evidence until the contrary provides: the loss of promissory note, bill of exchange and check was duly stamped. The presumption as to section 118 of the Act does not include presumption as to time of acceptance. In which one of the following case the Supreme Court held that rebutting statutory presumption under section 118A and 139 of Act, the evidence adduced on behalf of complainant could rely upon Goa Plast Limited versus Sico Ursel de Souza. Chapter 14 Cross of check, section 123 to 131. Effect of non-negotiable crossing mentioned under section 130. What is the meaning of payment of check crossed especially? The banker on whom it is drawn shall not pay it otherwise than to banker to whom it is crossed or his agent for collection. Chapter 17 of penalties in case on penalties in case of dishonor of check of certain checks for insufficiency of the fund in the account. Section 138 to 148. What is a statutory notice period for intimating dishonor of check under Section 138 of Negotiable Instrument Act? 1 month. A reside at Hyderabad, B at Calcutta and C at Delhi. A, B, C being together at Allahabad. B and C make joint promissory note payable on demand and deliver to A. A may sue B and C at all of the above. At Allahabad, where the cause of action arise, as at Kolkata, where B reside, at Delhi, where C reside. Offence under Section 138 of NIA is triable by the court on the basis of complaint by decree holder, complaint by holder or holder in due course. What is the maximum punishment under NIA? None of the above. For what term of imprisonment of an offender under Section 138 of the NIA can be punished? For a term which may extend to 2 years. Dishonor of check for insufficient fund in account related to Section 138. In an appeal by a drawer against his conviction under Section 138 of NIA, what minimum amount of fine compensation can be ordered by appellate court to deposit the appeal? 20%. Chapter 17, Section 138 and 142 was introduced in NIA Instrument Act by Act 66 of 1988. In case presentation of instrument for acceptance of payment is delayed, delay can be excused if it is caused by circumstances outside the control of holder and not because of the negligence, default or misconduct. How much time is given for complaint of dishonor of check? 30 days from intimation of dishonor. What is the presumption to draw under Section 139 of Negotiable Instrument? That the holder of the check receive the check for the discharge in whole or in part or any debt or other liability, in which judgment the Honorable Supreme Court laid down that a complaint based on second or successive dishonor of check is maintainable. If no complaint is based on earlier dishonor of check, followed by statutory notice, issue on the basis thereof had been filed. MRS Lether versus S. Pilanappa and others. In which provision the court may grant time to pay court fee in complaint under Section 138 of NIA. Section 33 of Court Fee Act 1970. How much punishment is provided under Section 138 of NIA? Imprisonment for term which extend to 2 years, or with fine which may extend to twice the amount of the check, or with both. For cognizance to be taken of the offence, dishonor of check of insufficient fund in account. Which of the following is prerequisite? The check must have been presented to the bank within a period of its validity or 6 months from the date on which it is drawn, whichever is earlier. Director of company is liable to offence committed by companies under Section 138 of NIA is if he is a person in charge and responsible to the company for conduct of the business of the company. The offence of dishonor of check exclude all above. Strict liability, absolute liability means rea. What are the defense available to the proceeding under Section 138 of NIA? All of the above. Absence of legally enforceable debt or liability, absence of legal notice of 15 days, lack of jurisdiction. That there must be a specific allegation regarding the role played by each of the director. Then only they are liable for prosecution under Section 138 of NIA, in which of the following case this statement was made. Rod Engineer India Limited versus Nagarjun Financial Limited. Nothing in Section 138 of NIA shall apply unless the check has been presented to the bank within a period of 6 months or within a period of its validity, whichever is earlier from the date on which it is drawn. Proceeding under Section 138 of Negotiable Instrument, which defense shall not be allowed. Drawer has no reason to believe when he issues a check it may be dishonor. A person sign a blank check and give the same to another person, holder, and the holder fill up the blank space pertaining the amount and date and present the same in his bank account, and it is dishonor. In such situation, which one of the following statement is correct? The holder will be entitled to maintain a complaint file upon the check being dishonored and being presented in the bank. Effect of notice under clause B of Section 138 of NIA is pay forfeit the right to again present the check for payment. What is the punishment prescribed for offence punishable under Section 138 of NIA? Imprisonment for term which be extended for 2 years, or with fine which may extended twice the amount of check, or with both. Which provision of NIA mandate that offence punishable under Section 138 shall be tried summarily? Section 143. Within how much time from date on complaint cause of action arises, the complaint of an offence punishable under Section 138 of NIA should be filed? 1 month. Under Section 138 of NIA, complaint may be made within 1 month from the date of cause of action arises. For the provision of attracting for the purpose of attracting the provision of Section 138 of NIA, a check has to be presented to the bank within a period of 3 months from the date on which it is drawn, or within the period of its validity, whichever is earlier. As per Section 147 of NIA, every offence punishable under this section is compoundable. Mens rea has no place while determining the penal liability under Section 138 of NIA. This statement is correct. NIA, when cause of action occurs if the check issued by the drawer is dishonored, on the date drawer of the check fail to make a payment of check amount to pay within 15 days from the receipt of the demand notice. Supreme Court has laid down certain direction to criminal court for speedy and expeditious disposal of cases filed under Section 138 of NIA in the case of Indian Bank Association and others versus Union of India. Section 138 of NIA Act deal with punishment of dishonor of check, in which court the complainant has to file an appeal against the order of acquittal under Section 138 of NIA Court of Session. What procedure of trial is provided to the court against the matter related to penalties if come under section of chapter 17 of NIA? Summary trial. Which one of the following section of NIA related to the presumption? D. All of these. It's 119, 137, 138. In a prosecution under Section 138 of NIA, it shall not be defense that the drawer had no reason to believe when he sue the check that check may be dishonored on the presentment. Which one of the following court empowered to try the offence relating to dishonor of check for insufficient etc. under NIA? Judicial Magistrate First Class. Power of court to try case summarily given under Section 143 of NIA. Every trial under Section 143 of NIA shall be conducted expeditiously as possible as, and the endeavor shall be made conclude the trial within 6 months from the date of filing of complaint. Every trial under section 143, an endeavor shall be concluded. An endeavor shall be made to conclude the trial within 6 months from the date of filing of complaint. Negotiable Instrument Act in recent Supreme Court case has held where the check amount with interest and cost to assist the court is paid by specific date. The court is entitled to close the proceeding in exercise of its power of under section 143 of the Act, read with section 258 of CRPC. This case is MS Meters and Instruments Private Limited and Anothers versus Kanchan Mehta. Section 141 of NI Act deal with the offence caused by the companies. Which one of the following is prescribed? Period of limitation for taking cognizance of the court against the offence committed under section 138 of NIA. "30 days from the date of cause of action arises, if the complainant made in writing to the court, who among the following empowered to take cognizance of an offence committed under section 138 of Negotiable Instrument Act 1881? Metropolitan Magistrate or Judicial Magistrate of the first class. Court can take cognizance of an offence punishable under section 138 of NIA upon complaint in writing made by the payee. Under section 138 of the Act, complaint may be made from the date on which the cause of action arises. 1 month. Under section 138 of the Act, maximum term of imprisonment is 2 years. Which one of the following section of NIA empower to the judicial magistrate of first class or metropolitan magistrate to try the offence relating to dishonor of check for insufficiency etc. Section 143(1). Written complaint should be made to the court from the date of cause of action within the period of 30 days. Which one of the following section of NIA deal with the offence committed by company under section 138? Section 141. Which one of the following is not meant by the term company for the purpose of section 141 of NIA? An educational institute. In which judgment under the NIA the Honorable Supreme Court held, though compounding requires consent of both parties, but even in the absence of such consent, the court can, in interest of justice, on being satisfied that the complaint has been duly compensated in its direction, close the proceeding and discharge the accused. Meters of Instrument Private Limited versus Kanchan Mehta. To constitute a offence under Section 138 Negotiable Instrument Act, within how much day the check should be presented to the bank from the date which it is drawn? 3 months. In which one of the following the Honorable Supreme Court held that in case arising from NIA, successively sentence may be directed to run concurrently if both transactions are part of single transaction? Syam Pal versus Dayavati Bisoya and others. Who among the following define jurisprudence as a knowledge of thing, divine and human, the science of right and wrong? Ulpen. The relation of Section 138 of NIA and 1881. The relation of Section 138 of NIA is with punishment for dishonor of check. Under Section 43 of NIA, the trial shall be made to conclude after filing the complaint within a period of 6 months. What is the main objective of Section 138 of NIA? Recovery of the check amount in cash check issued by payer to bounced. Payer is bounced. Check bouncing case charged under Section 138 of NIA is tried by Magistrate Court. The liability under Section 138 of NIA is strict liability. Who can entitled to make complaint for take cognizance of offence under Section 138 of NIA? Only the holder of the check. Complaint for taking cognizance of an offence under Section 138 of NIA has to be made within 3 months from cause of action. Who as a drawer of check can be prosecuted for non-payment of check due to insufficient fund under Section 138 of NIA? All of these. Only human being, only corporate body, only a firm. The offence of dishonor of check for insufficiency etc. of fund in account of drawer is punishable with imprisonment for a term which may extend to 2 years or with fine which may extend to twice the amount of check or both. A check can be presented within the period of 6 months from the date which is drawn any number of times. An offence under Section 138 of NIA is compoundable. Check of any amount. A court can take cognizance of an offence under Section 138 of NIA upon complainant Under Section 138 of NIA, maximum punishment of imprisonment and fine is 2 years and twice the amount of check. If the person committing an offence under Section 138 of NIA is the company, the following section deemed to be guilty of an offence. The following shall be deemed to be the guilty of the offence. A person in charge of responsible for the conduct of business of company as well as company. A complaint against the drawer check, dishonor of insufficiency etc. The fund must be made. Within 30 days of receipt of information from bank regarding the return of check is unpaid. Maximum sentence of fine which JMFC can impose for offence under Section 138 of NIA, twice the amount of check. Appeal against an order of acquittal of JMFC in respect of the offence under Section 138 can be filed Court of Session. A deemed notice in writing has given a drawer by payee under Section 138. The Negotiable Instrument Act, after receiving information of bank of dishonor of check within the period of 30 days. Who of the following are not liable to prosecute under Section 41 of NIA? All of the above. Any person nominated as a director by virtue of holding of an office or employment in central government. Any person nominated as a director by virtue of holding of office and employment of the state. Any person nominated as a director by virtue of holding on of any office or employment of central and state-owned controlled financial corporation. No court shall take a cognizance of any offence under Section 138 of NIA unless complaint is made from the date of accrual of cause of action. 30 days. Whether director is liable if check is issued on behalf of company dishonor. Yes, he is liable if he was charged of and was reasonable for the conduct of business of the company. For the purpose of Section 141 of NIA, company means all of the above: any corporate, a firm, other association of individual. Match the following: cognizance of offence, Section 142. Offence by companies and firm, Section 41. Dishonor of check of insufficiency of fund, Section 38. Power of court to try case summarily, Section 143. Presumption under Section 39 of NIA is in respect of that the check was issued for discharge of any debt. Section 138 of NIA provide a penal provision in case of dishonor of check if it is presented to the bank within a period of 3 months from the date on which it is drawn or within the period of the validity, whichever is earlier. Which one of the following proviso of Section 138 of NIA? Notice of 15 days in case of failure of payment of check. C. Clause C. The presumption regarding the dishonor of check on production of a bank slip is rebutable. An offence under Section 138 of NIA was tried summarily, but court imposed the accused a sentence of imprisonment for 1 year. The sentence is legal. For the purpose of Section 141 of NIA, the company does not mean and include proprietor concerned. It shall not be defense in prosecution of any offence under Section 138 that drawer has no reason to believe when he issue the check that check may dishonor or presentment for the reason stated in the section. This statement is true. Which one of the following circumstances will attract the provision of Section 138 of NIA? In all of the above circumstances, check dishonored due to insufficiency of fund, check returned by the bank unpaid on the ground that account is closed, check returned by the bank unpaid due to stop payment of instruction by drawer. What is the presumption under Section 139 of NIA? That the check was issued for discharge of any debt and liability. Under NIA, how many days after service of notice deemed to drawer, the cause of action arises against drawer if he failed to make the payment? "15 days. Under NIA, for filing a complaint under Section 138 of the Act, essential condition is the check was returned for insufficient fund in the account. The cognizance of offence under Section 138 can be taken by JMFC has territorial jurisdiction at place where check is dishonored by the bank on which it is drawn. Which section provide that offence under NIA is compoundable? 147. Offence under NIA is compoundable under Section 147. Which one of the following statement is correct in relation to the bouncing of the check? Offence of check of bouncing is compoundable offence. Offence under NIA is triable by Judicial Magistrate First Class. The provision of no court inferior to Metropolitan Magistrate or Judicial Magistrate of First Class shall try the offence punishable under Section 138 exists under Clause C of Section 142 of NIA. Which section of NIA exclude defense that drawer has no reason to believe when he issue a check that it may be dishonor or presentment for the reason stated in Section 138 of the Act? Section 140. In trial of offence under the NIA, provisions of Section 262 and 265 of the CRPC shall apply. Which of the following of NIA provide that where a person is nominated as a director of the company by virtue of holding any office of employment in central government and state government, as the case may be, he shall not be held liable of offence under section 138 committed by the company. Proviso 2 of section 141 subclause 1, under which provision of NIA a person who is nominated by director of company by virtue of holding over any office employment in central government or state government or financial corporation owned or controlled by central government, he is not liable for prosecution. Section 141. Which one of the following is correct statement of law as per section 138 and 142 of NIA? All of the above. A check has to presented to bank within a period of 6 months from the date of drawn within the period of validity, whichever is earlier. Notice within 30 days of receipt of information from bank regarding the check is unpaid has to serve upon drawer demanding payment of the amount of money. On failure of drawer of such check to make payment within 15 days of receipt of such notice, the payee or the holder has to file a complaint within 1 month thereof. The delay in filing of complaint under section 138 can be condoned. Section 142 of NIA. In which one of the following judgment of Supreme Court held only those court within whose territorial limit drawee of bank is situated would have jurisdiction to try case of offence under section 138 of NIA? Darsrat Roop Singh Rathod versus State of Maharashtra and another. In which one of the following cases Supreme Court held that provision of section 141 of NIA does not contain a condition that prosecution of complaint is sine qua non for prosecution of other person. The liability of director etc. is vicarious will flow from liability of company and firm. Muhammad Isa Kushani versus Raja Mouli. Court shall not take cognizance of any offence punishable under section 138 of NIA unless complaint made within 1 month. Chapter 17 was inserted into NIA Amendment Act in the year 1988. Match. Cognizance of offence, section 142. Power to try case summarily, section 143. Defense which may not be allowed in any prosecution under section 138. Section 140. Presumption as to favor of holder, section 139. A complaint against the offence under section 138 of the Act must be in writing. Offence under NIA are cognizable and compoundable. Amendment in NIA made in 1988 has introduced the important provision relating to dishonor of check. Before initiating criminal proceeding of dishonor of check, within how many days of receipt of information of dishonor should be paid to the check issue a notice 15 days. Appeal against the order of acquittal passed by JMFC in respect of offence under section 130 of NIA would lie in Court of Session. Check issue under the same transaction of dishonor, one complaint in respect of all check is maintainable if a prosecution of offence under section 138 of the Act, the drawer had no reason to believe when he issued the check that check may be dishonored on presentment. Shall not be a defense. Can magistrate order investigation on allegation of offence under section 138? No. The maximum amount which may be awarded by interim compensation under section 143A of NIA is 20% of amount of check. What sentence can be awarded to be convicted of offence under section 138 of NIA? Imprisonment for term which may extend to 2 years of fine or which may extend to twice of the amount of the check or both. Section 118 of NIA was presumptions shall be not made by the holder of check receive the check for dishonor, discharge of any debt or other liability. The maximum amount of fine which can be imposed under section 138 of NIA is twice the check of amount. Miscellaneous. Under NIA, promissory note can be drawn minimum period of no time limited is fixed. Instruction of stop payment remain valid for none of these. Section 100 of NIA deal with protest. Which one of the following is true about bank draft? It is very much like a check. Which one of the following is not a negotiable instrument? Hundis. Which option is correct where complaint under section 138 of the Act filed at premature stage before expiry of period prescribed in demand of notice of 15 days? Cognizance can be taken afterward when cause of action arises. Under NIA, how many times a holder of check can present it before a bank during period of its validity? Any number of times. A person who receives NIA in good faith for valuable consideration is known as holder in due course. All check are bill of exchange, but all bill of exchange are not check. True. In order to rebut the presumption under section 138 and 118 of NIA, accused may rebut the presumption on the principle of preponderance of probability. Under NIA, an instrument in writing contains an unconditional undertaking signed by the maker to pay a certain sum of money or to be ordered of a certain person or a bearer of the instrument is a promissory note. Bill of lading is neither A nor B. A negotiable instrument like bill of exchange, not. A negotiable instrument like a promissory note, not. Which one of the following is not true with respect to negotiable instrument? A check cannot be considered as a bill of exchange. Read the following statement. There is a rebuttable presumption that check bearing date was made or drawn on such date. This one is only right. Under which provision of NIA, appellate court may order the appellant to deposit a sum which shall be minimum of 20% and fine of compensation awarded by the trial court. Section 148. Which one of the following section enables the court to cancel the bond and bail bond? 466A. BATANA stand for BATNA. Best alternative to negotiate to a negotiated agreement. The surety has no right to restrain execution against him until creditor exhausted all the remedy against the principal debtor. The liability of surety coexistive with that principal dated, unless it is otherwise provided in the contract.